Mr. Speaker, for the purposes of debate only, I yield the customary 30 minutes to the gentleman from Florida, Mr. Hastings, pending which I yield myself such time as I may consume. During the consideration of this resolution, all time is yielded for the purposes of debate only. Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and to include extraneous materials on House Resolution 682 currently under consideration.
Without objection.
Thank you, Mr. Speaker. I am pleased to bring forward this rule on behalf of the Rules Committee. The rule provides for consideration of S139, the FISA Amendments Reauthorization Act. The rule provides for 1-hour debate with 40 minutes equally divided and controlled by the chair and ranking member of the House Permanent Select Committee on Intelligence and 20 minutes equally divided and controlled by the chairman and ranking member of the Judiciary Committee. The rule also provides for a motion to recommit. Additionally, the rule makes an order and amendment offered by Mr. Amash, representing ideas from members of both sides of the aisle. Yesterday, the Rules Committee received testimony from numerous members, including Intelligence Committee Chairman Nunes, the ranking member Mr. Schiff. We also heard from Judiciary Committee Ranking Member Nadler, Congressman Farenthold, Congressman Amash, Congresswoman Lofgren, and also Congressman Poe. In addition to the vigorous debate on this legislation before the Rules Committee, both the Judiciary Committee and Intelligence Committee held markups on legislation to reauthorize Section 702 of the Foreign Intelligence Surveillance Act. Today, we have the opportunity to pass an important piece of legislation that will enhance our national security and strengthen protections of Americans' privacy. Mr. Chairman, I would like to publicly thank Chairman Goodlatte and Chairman Nunes for the important work on this legislation. As a result of their efforts, the legislation we will consider today will protect the privacy rights of individual Americans without hindering the intelligence community's ability to gain valuable intelligence about the schemes and identities of our enemies. Our government's most fundamental responsibilities are to defend the American people from harm and to protect their liberties. The value that we place on these duties is reflected by the fact that they are enshrined in the preamble to the Constitution. To provide for our common defense, the dedicated men and women of the intelligence community work tirelessly to defeat the efforts of our foreign adversaries, whether they are terrorists, hostile foreign states, or nuclear proliferators. Our Constitution tasks each branch of government, legislative, executive, and judicial, with constantly working to protect the liberty of every American. With the bill provided for by this rule, the Chamber will be considering legislation that will help us better achieve both. The FISA Amendments Reauthorization Act will extend the Foreign Intelligence Surveillance Act, or FISA, Title VII for 6 years, while increasing oversight of its implementation at every level and providing for more robust privacy protections for Americans. Section 702 of FISA has proven to be an invaluable tool for collecting foreign intelligence and providing insight into the plans and intentions of our enemies. It is one of the National Security Administration's most important operational authorities. It permits the government to conduct targeted surveillance of foreign persons located outside the United States with the compelled assistance of electronic communication service providers to acquire foreign intelligence information. Mr. Speaker, this program's importance to the national security cannot be overstated. While many of the examples of successes are classified in nature, I can tell you here today that it has helped protect the homeland and American people. One declassified example that I can share with you concerns the story of Haji Aman, who rose through the ranks of ISIS, eventually becoming the terrorist organization's second in command. For more than 2 years, the intelligence community searched for Aman. During that period, the NSA used their Section 702 programs to target his communication and his close associates. Their resourcefulness, together with these 702 resources, eventually led them to him. Mr. Speaker, the gentleman was a terrorist. He was killed, he was a murderer, and Mr. Speaker, Mr. Aman is killed by U.S. Special Forces on March 24, 2016 during an attempt to apprehend him. We may not see every victory that the 702 program delivers on behalf of the innocent Americans, but these initiatives help protect Americans every day. Let us pause to note, however, that with the broad authority granted by a program like 702 to collect foreign intelligence information to fight our foreign enemies, it must come expansive safeguards against abuse of that authority and the expansive oversight of its use. To ensure that the authorities under Section 702 do not come into conflict with the liberty and privacy interests of the American people, the FISA Amendments Act expands substantially on the already extensive safeguard. Mr. Speaker, as I have said, each branch of government is responsible for protecting the liberties of the American people. In the executive branch, there are extensive internal controls that require agency heads and the Attorney General to review and approve of actions under 702. Additionally, the Inspector General for the intelligence community and the Department of Justice are tasked with a comprehensive review of this program's implementation. Mandatory internal procedures known as targeting and minimization procedures also govern the collection, use, and dissemination of information are in place at each agency that uses FISA Section 702. The FISA Amendments Reauthorization Act expands upon the internal protections by requiring each agency to also adopt querying procedures to control how each agency searches its database for 702 acquired communications. This brings me to the judicial branch. Under the current law, the targeting and minimization procedures must be approved annually by the Foreign Intelligence Surveillance Court, or FISC, which is made up of a rotating group of Article III judges. The FISC, and with the aid of amicus curiae briefs and the technical experts, engage in an exhaustive review and consideration of Section 702's implementation for compliance with the Constitution and the law. This legislation will enhance the FISC's consideration of privacy issues by providing the FISC with the authority to compensate amicus briefs and technical experts. Finally, there is Congress, where we come to. The Committees on Judiciary and Intelligence have conducted multiple oversight hearings and meetings in both classified and unclassified settings. Numerous insights came from those hearings, and the legislation that will be considered under today's rule reflects them well. The bill makes a number of improvements that will enhance the congressional oversight in coming years. But, Mr. Speaker, it's time to remember one more group that remains critical to protecting Americans' liberties: American men and women themselves. This legislation will improve transparency and public oversight of FISA Section 702 by requiring the Director of National Intelligence and the Attorney General to conduct declassification review and publicly release the FISA Section 702 minimization procedures every year. Mr. Speaker, the most important reform contained in this legislation constitutes the most substantial reform to the program since its inception. Under this legislation, the FBI will be required, when conducting a criminal investigation of a U.S. person, to obtain a warrant from the FISC prior to accessing the content of the communications that were acquired using 702. 702 information is collected for the purpose of foreign intelligence operations, and this critical new requirement forecloses the possibility that the FBI agents investigating Americans for traditional crimes would be able to use 702 information in such domestic investigations. In addition to the numerous safeguards currently in place and added by this legislation, Americans are guaranteed their right of privacy by the Fourth Amendment to the United States Constitution. I took an oath to uphold and defend the Constitution, and the oath guides every action I take in this chamber. The FISA Amendments Reauthorization Act ensures that the Fourth Amendment rights of Americans are upheld and includes additional safeguards on top of constitutionally guaranteed rights. Mr. Speaker, we have reviewed the importance of the FISA Amendments Reauthorization Act in stopping terrorist attacks and protecting the American people. But this point bears repeating. This program allows the government to obtain the communication of foreigners outside the United States, including foreign terrorist threats, in support of the counterterrorism efforts worldwide, and it has allowed us to respond to threats to our country. Now let me tell you a little bit about what the 702 program is not. It is not a bulk collection of data. It cannot be used to target Americans, and it cannot be used to target individuals located inside the United States. Mr. Speaker, the FISA Amendments Reauthorization Act is an example of what Congress can accomplish when we work together to find solutions to our nation's weightiest challenges. But, Mr. Speaker, I also, before I close my opening, will acknowledge that there is a lot of difference of opinion, as there should be, upon this bill. But at the end of the day, progress has been made, protections have been implemented, and the security of our country must be taken into account. That is why this bill needs to pass, and the amendments that were brought forward need to fail. We need to push this forward and begin the process in continuing to protect our private citizens' personal responsibilities and liberties, but also at the same time making sure that our intelligence communities and those entrusted with the sacred duty of protecting this country have the tools they need to do that. Anything else would be less than what we should be here with that. And with that, I reserve the balance of my time.
Gentleman from Georgia reserves the balance of his time. Gentleman from Florida is recognized.
Thank you very much, Mr. Speaker. And I thank the gentleman from Georgia, my friend Mr. Collins, for yielding to me the customary 30 minutes for debate. And Mr. Speaker, I'll yield myself such time as I may consume.
The gentleman from Florida is recognized.
I stand here today with the rest of my Democratic colleagues in utter amazement at the dizzying dysfunction exhibited by our friends across the aisle. For reasons beyond understanding, we have to vote on the reauthorization of Section 702 of the Foreign Intelligence Surveillance Act because late last year, the Republican leadership chose to prioritize massive tax cuts for their wealthy donors over the safety of American citizens. Like so many other important issues, House Republicans decided to punt on the reauthorization of 702 by simply extending it to January 19th of this year. Coincidentally, the same date the government will possibly shut down. Mr. Speaker, as a former judge and the former vice chairman of the House Permanent Select Committee on Intelligence, I do occupy a unique vantage point in the ongoing debate between the need to steadfastly protect the Fourth Amendment of the Constitution while also ensuring that those in the intelligence community have the tools they need to keep our country safe from those who wish to do us grave harm. Putting the finer points on this debate aside for a moment, I can tell you with complete certainty that such a debate deserves to be lengthy and thorough, neither of which have happened here. I was concerned to learn, if not a bit dismayed, that the House Intelligence Subcommittee, which has oversight jurisdiction of the National Security Agency, did not hold a single hearing on today's bill. In fact, the full committee did not even hold a single hearing on this important piece of legislation. Think about that. As the Republicans approach the need to discuss the reauthorization of one of the more important tools to fight terrorism that simultaneously brings along legitimate and important Fourth Amendment concerns, the majority, in all their wisdom, thought it prudent to hold exactly 0 hearings on such an important matter. That is a brazenly inept way to govern, and to add insult to injury, I'm told that members of the committee were given about 36 hours to read the bill before having to vote it out of our committee. Side note here, the bill they were given 36 hours to review is not actually the bill we have before us today, because the majority had to use a Rules Committee print to fix some of the most troublesome parts of the original bill in order to obtain my friend, the ranking member, Adam Schiff's support. Mr. Speaker, without a doubt, that support did not come easily, and important changes were made to the bill as it was presented to the committee in its original form. For example, Mr. Schiff was able to ensure that the Republicans' unmasking language was removed from today's bill. The removal of such language ensures that one of the Republicans' most heinous political stunts is not codified into law. This was and is a significant improvement. Moreover, the Republicans removed a controversial expansion of the definition of agent of foreign power, which concerned privacy and technology groups. Today's bill also addresses what is known as abouts collection. This is the collection of communications that are not to or from a target, but rather communications that merely reference the target. The NSA itself shut down this collection method earlier this year. The legislation before us today will allow such collection to resume, but only if the NSA first devises a way of doing so that addresses privacy concerns, obtains permission from the Foreign Intelligence Surveillance Court, and Congress does not object after a 30-day review period. Now, this may seem to be a better option than what I'm sure many, if not most, Republicans wanted, which is the full-scale re-implementation of About's collection. But considering how much difficulty the majority has in simply keeping the lights on around this place, I think it's fair to question their ability to provide meaningful oversight in just 30 days. Again, this is simply evidence for the need to return back to regular order under which bills are fully and fairly considered. Regardless of where one comes down on this issue, I can assure you that there are members on both sides of the aisle that are sick and tired of being shut out of important policy discussions concerning subjects like those before us today. Mr. Speaker, I reserve the balance of my time.
Gentleman from Florida reserves his time. Gentleman from Georgia.
Thank you, Mr. Speaker. At this time, I would yield 3 minutes to Mr. Sensenbrenner from Wisconsin, a fellow member of the Judiciary Committee and former chair of that committee.
Gentleman is recognized for 3 minutes.
Thank you, Mr. Speaker. I rise today in opposition to S-139, which is the FISA Reauthorization Act. I have stood on this floor debating the Patriot Act after 9/11. I fought for reforms in 2015 with the USA Freedom Act. And now we are debating the latest need to balance privacy and security. Since Congress last reauthorized Section 702, we have learned a great deal about the operation of this program. The revelations have highlighted the risks that it poses to privacy and civil liberties. This program needs to be reformed. But, Mr. Speaker, this is not the bill to do it. Rather than providing meaningful reforms, the FISA Amendments Reauthorization Act would reauthorize Section 702. However, as we are all well aware, the program routinely sweeps up millions of innocent Americans' emails. The warrant requirement in this bill applies to only fully predicated official investigations, and not to the hundreds of thousands of searches the FBI runs every day, just to run down a lead or check out a tip. The loopholes are too great to ensure proper protection. In this morning's Washington Post on page A4, an article says in part, FBI officials told aides of the gentleman from New York, Mr. Nadler, last week, that under the proposed bill, they anticipate rarely, if ever, needing permission from the Foreign Intelligence Surveillance Court to review query results, according to one of the aides. And this was not denied by the ranking member of the Intelligence Committee, the gentleman from Florida, Mr. Schiff. We're going to hear an awful lot about warrants on the floor and how this fixes the problem. But here the FBI has said, in no uncertain terms, to one of our congressional aides that they're never going to have to use this warrant requirement, which was drafted by the Justice Department that has opposed warrants all along. If ever we have seen the fox not only watching the hen house, but inside the hen house, this is it. It isn't even a fig leaf, big, small, or otherwise. It is simply a way to divert attention of this Congress away from what is really going on. Furthermore, the bill would provide a path for the NSA to restart the practice of about collection, which has been described by the ranking member. The proposal grants some committees 30 days to review any effort to turn about collection back on, giving Congress little or no say on this matter. We all know we can't do anything in 30 days around here, and yet the bill restricts us from doing that. Finding a bipartisan and balanced solution is very possible. I know because I've done it twice with the Patriot Act and the Freedom Act. And then I joined, may I have an additional 30 seconds?
I'll give the gentleman just 30 more seconds.
The House Judiciary Committee passed the USA Liberty Act with bipartisan votes. This bill fails to do these necessary reforms. The program should be authorized if done in the right way. This bill is the wrong way. It is time for Congress to put the F for foreign back into FISA. There is no F for foreign in this bill. And I yield back.
Gentleman yields back his time. Gentleman from Georgia reserves his time. Gentleman from Florida.
Thank you very much, Mr. Speaker. I'm very pleased to yield 4 minutes to the distinguished gentlewoman from California, my friend, Ms. Lofgren, from the Judiciary Subcommittee on Immigration and Border Security.
Gentlelady is recognized for 4 minutes.
Mr. Speaker, thank you very much. I agree with Mr. Sensenbrenner for the reasons he's outlined that this bill should not become law. However, I am also speaking in favor of the Amash amendment that has been put in order that would fix the problems that he has so eloquently outlined. You know, before 702 was enacted into law, the NSA and the FBI would need to get a probable cause warrant to collect this information. And we made a major change that allows this information to be collected when a foreigner is communicating with an American. And when you go to the About collection, which the underlying bill would codify, even when that doesn't occur, when there's merely discussion of a foreigner. That's not what I think our Constitution requires, and we did not outsource to the judicial branch or the executive branch the decision on what the Constitution requires us to do. Now, we have learned that there is a vast amount of information being collected. We can't go into the details of that in an open session. Just we have been told by Admiral Rogers the scope of this, and that the database that is so-called incidentally collected because of the architecture of the internet could be searched for Americans without a warrant is not consistent with the protections outlined in the Fourth Amendment to the Constitution. The Amash Amendment, which is basically the USA Rights Act, ends these backdoor searches by requiring a warrant. It ends reverse targeting. It bans the Abouts collection and prohibits the collection of domestic communications, prevents the misuse of information on Americans, and is something that we should support. Now, in a letter to the Senate in October, a coalition of groups said this: the USA Rights Act, which is essentially the Amash Amendment, is markedly superior to all current legislative proposals to reauthorize Section 702. Who said that? The American Civil Liberties Union and FreedomWorks, the NAACP, but also the Project on Government Oversight and Color of Change. This is a broad left-right coalition that has come together, even though there are many things we disagree on, because we agree on one thing. When we took an oath to defend the Constitution on our first day of this session, we didn't take that oath to defend the Constitution when it's convenient, when we feel like it. No, we took that oath to defend the Constitution every day, in every way, with every bill. And without the Amash Amendment, this bill falls short. Just a note on where we are in the timing. It's true that this has been delayed, I would say unconscionably delayed, for this proceeding. But if we have more time than has been suggested, under the existing act, it provides that if there is an existing order from the FISA court that order remains in effect even if the underlying bill lapses. We have an order that extends into late April. So we have a deadline, but it's not this week, and it's not next week. We owe it to our constituents. We owe it to our obligation to the Constitution to get this right. You know, when Jim Sensenbrenner, who is someone who is, nobody's going to question his conservative credentials, when Judge Poe and Zoe Lofgren and Jerry Nadler come to the same agreement on the Constitution, I would hope that our colleagues would listen. Vote for the Amash Amendment, and if it does not pass, vote against the bill. And I yield back.
Gentlelady yields back. Gentleman from Florida reserves his time. Gentleman from Georgia.
Thank you, Mr. Speaker. Before I yield, a couple of things to clarify here. This is an urgent matter. This is not, and although the gentlelady spoke of this in the sense that the existing orders would stay in place, she fails to mention, and others have failed to talk about, that any new orders or even currently existing orders being enforced by the intelligence community, which is said under that sort of pale of direction that they won't. So I guess if you're satisfied protecting the country with existing orders and existing threats that lasted yesterday, but I'll guarantee you somebody else woke up this morning wanting to do us harm, and I want to have the intelligence community to be able to address that in a way that is prudent and proper, which is what I feel like is happening here. I will not yield to the gentlelady. The other issue here is, and I want to make this very clear, there are strong opinions, and I respect the gentlelady from California immensely, although I still will not yield. I relay and have had similar concerns that she has had over the process. And I have voted with her on several times to move forward. But we have moved forward, and there are, I believe, protections in this bill. So when we also talk about, as we go forward, and there's going to be a lot of passionate rhetoric about who is looking out for who and reminding us of our oaths. I took the oath here, just as the gentlelady did when we started this new session. But I also took another oath in the United States Air Force and also served in Iraq and also served in that time currently in the military. And when we have that also oath as well, I will not take a backseat to anyone who can constantly disagree about where we are. This is a good bill. This is something that I would love to see in different ways changed. But this is the art of where we are now and protecting our country. With that, I yield 3 minutes to the gentlelady from Wyoming.
Gentlelady is recognized for 3 minutes.
Thank you very much, Mr. Speaker. Mr. Speaker, I rise in support of reauthorizing FISA 702. You know, it's interesting, Mr. Speaker, to hear my colleagues on the other side of the aisle talk about unconscionable delaying tactics or talking about the need for regular order. I would point out, Mr. Speaker, that just today on this floor, we have watched once again our colleagues on the other side of the aisle playing games. We have had this particular debate now delayed by the games that their members have been playing over the course of the last several hours with motion after motion to adjourn. And that is, Mr. Speaker, what I believe is unconscionable. This is a bill that is a bipartisan bill. The ranking member of the Intel Committee, as well as the chairman of the Intel Committee, worked very hard to come to agreement on this bill. I would argue, if anything, Mr. Speaker, the bill goes too far in terms of beginning the process that we cannot begin of putting walls up. All of us lived through 9/11. And we know, Mr. Speaker, that one of the things that we saw that day was what can happen when we make it much more difficult for our law enforcement and our intelligence agencies to connect the dots, much more difficult for them to stop terrorist attacks against this nation. Mr. Speaker, this is a bill that goes directly towards those issues. This is one of the most important pieces of policy and of authority that the National Security Agency has. And I think it's very important for people who are listening to this debate to recognize that this authority is an authority that allows surveillance of foreign nationals on foreign territory, not in the United States. And I would urge my colleagues, particularly when we've got a bill that is a bipartisan product, that's a product that has been worked on and agreed to in a bipartisan manner, that it is unconscionable for them to delay, unconscionable for them to hold the nation's security hostage. And we are seeing it, Mr. Speaker, not just with respect to this particular piece of legislation, but we are seeing it, Mr. Speaker, with respect to the entire negotiations underway today over the budget for the nation. We have seen a situation where, as they did today, trying to accuse us of holding DACA hostage, of holding DACA individuals hostage. That's not what's happening, Mr. Speaker. The Democrats in this House, Mr. Speaker, are in fact holding our national security hostage, and they're doing it with respect to the funds that our military needs as well. We are a nation today that is facing grave and growing threats. We are a nation that is putting tremendous demands on our intelligence service, on our intelligence professionals, and on our men and women in uniform. And I think that every member of this body who decides to play games rather than do what is right and what is necessary and what our constitutional obligation and our oath requires ought to think, as they're doing that, what does it mean to the mothers and fathers across this nation who have children who are deployed for the defense of the nation, the mothers and fathers across this nation who know that we are sending their children into harm's way. And the Democrats in this body, Mr. Speaker, consistently continue to hold up the funding that our military needs, and in this case in particular, to hold up the reauthorization of this crucial piece of policy. So, Mr. Speaker, I rise in strong support of the reauthorization of this bill, and I yield back the balance of my time.
Gentlelady yields back her time. Gentleman from Georgia reserves his time. Gentleman from Florida.
Thank you very much, Mr. Speaker. I'm amused by my friend from the Rules Committee's assertion that today, because of protests with reference to DACA, that members of my party were protesting that concern. I'm also amused that they're in the majority, and she accuses us of delaying when in fact this measure was scheduled 2 or 3 months ago and could have been brought to the floor. But no, you were busy about tax cuts, and so you didn't get around to allowing for this important matter to be brought to the floor. Mr. Speaker, to respond to my good friend from Georgia, I yield 30 seconds to Ms. Lofgren.
Gentlelady's recognized.
I just wanted to respond that the NSA will not go dark, and I think it's important that we understand that. We're collecting the content of phone calls, emails, text messages, videos, pictures of Americans, putting it in a database and querying it, searching it without a probable cause warrant. That's the state today. And that will continue until reform is done. It will not go dark, and I thought it was important to make that clear. And I thank the gentleman. I know you want to yield to my colleague from the Judiciary Committee, but to have the chance to clarify that.
Gentlelady's time has expired. Gentleman from Florida reserves his time. Gentleman from Georgia.
I appreciate the gentlelady from California attempting to clarify. Again, I stand by my statement, and the simple fact is it will not go, is the statement of not go dark, but the issue is we go further here in the collection happening, but having to, how we use that and how we deal with that in a national security conflict, there is an interesting issue here, and there is an issue that could keep us from doing what we need to do. And I appreciate, again, this is a debate that we can have. This is the debate that we need to have on this floor. But there is a difference of opinion here, and in this instance, I think with the pervasive efforts put in place, I believe that this program is one worth keeping. With that, I yield 4 minutes to the gentleman from Pennsylvania, Mr. Fitzpatrick, a former FBI special agent.
Gentleman's recognized for 4 minutes.
Thank you, Mr. Speaker. Mr. Speaker, I rise today in strong support of reauthorizing Section 702 of the Foreign Intelligence Surveillance Act, which is due to expire. And as a 14-year FBI special agent, including significant time as a counterterrorism agent, I am an eyewitness to the importance of this program and the deliberate and lawful manner in which it's used. The fact is, Section 702 is a critical tool that the intelligence community uses properly to target non-U.S. persons located outside of the United States to acquire information that is vital to our nation's security. Equally as important, this crucial program has operated under strict rules and has been carefully overseen by all 3 branches of our government to protect the privacy and civil liberties of all Americans. As we have seen both in our country and abroad, proper surveillance and law enforcement is vital to protect us against terror attacks, especially lone attacker scenarios. And as terror groups like ISIS continue to lose territory in Iraq and Syria, our intelligence community has warned that we will see more of these one-off attacks as opposed to more traditional conspiracies. At a hearing of the Homeland Security Committee, I asked FBI Director Chris Wray about this program as part of our national security posture. He said, despite the high volume of threats, there are few dots that can actually be connected in regard to these more loosely organized situations. Information already lawfully obtained by the FBI is crucial in, as he said, understanding, quote, which threats are real and which ones are more aspirational, end quote. Section 702 allows the national security professionals to query information to determine whether a tip from state or local law enforcement or others is credible, and it begins the process of marshaling resources to head off potential threats. Allowing Section 02 to expire would leave America vulnerable at a time when we need this protection the most. As Director Wray clearly stated, if Section 702 is walked back, we will be starting to rebuild the wall that existed before 9/11. Mr. Speaker, with today's terror landscape, we cannot go backwards when proven legal means exist to keep Americans safe. I urge my colleagues, Democrat and Republican alike, to support this vital national security measure. The safety and security of the families we represent depend on the passage of this measure. Let us get this done for them. I yield back.
Gentleman yields back. Gentleman from Georgia reserves his time. Gentleman from Florida.
Thank you very much, Mr. Speaker. I'm very pleased to yield 4 minutes to the distinguished gentlewoman from Texas, the ranking member of the Judiciary Subcommittee, and a good friend of mine. The subcommittee she represents is Crime, Terrorism, Homeland Security, and Investigation. Ms. Jackson-Lee.
Gentlelady is recognized for 4 minutes.
Let me thank the gentleman from Florida for his astute assessment and analysis in his earlier remarks today, particularly sharing with us his experience on the Intelligence Committee. I thank him for mentioning the fact that I serve as a ranking member on the Crime, Terrorism, Homeland Security, and Investigations. In that capacity, that committee certainly encounters not only our nation's law enforcement, but many of the issues dealing with terrorism, including the work on Homeland Security. With that in mind, I want to simply say to my colleagues, and certainly to my good friend who served and dedicated his life to the FBI for 14 years, none of us who over the past couple of months will take a back seat to championing the FBI and thanking the FBI and recognizing the FBI for the very valiant work that it does. Being on the Judiciary Committee for the number of years that I've served, I've worked with almost every FBI director and agents, particularly the SACs in my particular jurisdiction, and have been engaged in discussions on the resources and needs of that organization. Again, we thank them for their service. I would offer to say that the position I take now today is to protect the FBI and to protect the American people. With that in mind, I'd like to submit into the record, interestingly enough, an article written by Sheila Jackson-Lee, Protecting America, Protecting Americans, dated October 16, 2007. I ask unanimous consent.
Without objection.
That article suggests that we have the responsibility to protect America and Americans. And I would make the point to my good friend who mentioned that men and women or families sending their young children, young people over to battlegrounds. They're absolutely right. And those young people that are going over to battlegrounds are going over on the basis of freedom. Their parents sacrificed the fact, these loved ones sacrificed their young people because they believe so much in the freedom of this nation. Well, I will tell you that the Section 702 in the underlying bill, there is no freedom in this particular bill. And that is why we need to address the question in a thoughtful manner. I don't mind if we extend this to have a longer debate so that we can work through some of our concerns. Let me be clear that S-139 fails to address the core concern of members of Congress and the American public. The government's use of Section 702 information against United States citizens in investigations that have nothing to do with national security. That is a crux of our advocacy for both the Amash Amendment, joined by myself and Zoe Lofgren and Ted Poe and many others. It is not to undermine the security of this nation. It is to give substance to those families who sacrifice and send their young men and women to faraway places. The warrant requirement contained in the bill is riddled with loopholes and applies only to fully predicated official FBI investigations, not to the hundreds of thousands of searches that the FBI runs runs every day to run down a lead or check out a tip. S-139 exacerbates existing problems with Section 702 by codifying the so-called about collection, a type of surveillance that was shut down after it twice failed to meet the Fourth Amendment scrutiny. S-139 is universally opposed by technology companies, privacy and civil liberties groups across the political spectrum. Let me read briefly what the Amash Amendment really says. It is not something that would stop security, surveillance, and work in its tracks. What it does is, except as provided in subparagraph C or D, no officer, agent, or employee of the United States may conduct a query of information acquired under subsection A in an effort to find communications of or about a particular person if there's reason to believe such person is a United States person. Protecting the First Amendment of freedom of speech and all of that, but matched with the important amendment of the Fourth Amendment, which of course is unreasonable search and seizures. An application by the Attorney General to a judge of the Foreign Intelligence Surveillance Court that describes the determination of the Attorney General that there is probable cause to believe that such communications provide evidence of a crime, such person is a foreign power or an agent of a foreign policy. This is a minimal standard.
Yield the gentlelady an additional 30 seconds.
Gentlelady is recognized.
I thank the gentleman. This is a minimal standard of which every American should expect and is owed. It is a minimal standard upon which we stand the Constitution. We're missing what our role is here. It is not to rush through a FISA bill that has been delayed by my Republican friends. More importantly, it is to do right by the American people. We are not doing right by the American people. And I remember fighting against reverse targeting, a major issue in our work on the Freedom Act and the Patriot Act. Now today, in 2017, going into 2018, in 2018, it is important to remember that 9/11 was to not turn terror on Americans. It was to protect us from terrorism and to withstand that with the upholding of the Constitution. I ask my colleagues to oppose the underlying bill. I yield back.
Gentleman from Florida reserves his time. Gentleman from Georgia.
Thank you, Mr. Speaker. Just real briefly, I think one of the issues here is this discussion of riddled with loopholes and riddled with anybody. It's just a reminder that agencies not already defined in this cannot just do random searches of this database. This is something that we just, again, let's just push back on the facts of the case. And with that, I'll reserve the balance of my time.
Gentleman reserves his time. Gentleman from Florida.
Mr. Speaker, I'm very pleased to yield 4 minutes to the distinguished gentleman from Washington, my good friend, Mr. Heck.
Gentleman's recognized for 4 minutes.
Thank you, Mr. Speaker. I rise today to ask my colleagues to say pause, take a step back, reject the rule, and give ourselves a chance to frankly do it better. FISA reauthorization is inarguably one of the most consequential votes we will take in this Congress because the constitutional stakes are so high. Civil liberties are the core of our Bill of Rights, and we are asked to take action that affects them in the name of keeping us safe. I get that, but it's critical that we get it right, and I think we can do better. To make decisions of this magnitude, we should have the most robust process possible, full and open debate, and input from the stakeholders, thoughtful deliberations by the members, and the process for this bill thus far has decidedly not been great. It was written and rewritten in secret and with minimal debate or stakeholder input. But, this is a big but. I'm actually optimistic because I've seen a change in the last few days, and I think we have an opportunity here. The administration is suddenly engaged, and we're seeing vibrant debate from stakeholders in the technology sector, civil liberties advocates. Members have had very serious discussions, including here on the floor today, but in the halls, offering amendments to rules, unfortunately, which are not being allowed, save one. We're being asked to shut all that down, that opportunity, and push through an extension that will run for 6 years. And frankly, stop and think. 6 years in the world of technology it's an eternity. So for all these reasons, I ask my fellow members to join me in opposing this rule and instead allow the House an opportunity to work its will, to take a little more time and to do it better, because we really do need to wrestle with privacy, what privacy means in a world where our entire personal lives are stored somewhere online as ones and zeros. And frankly, that's happening at an even faster pace than it is now. We need to debate how the Fourth Amendment protects us against search and seizures applying to our digital records. We're all being rendered into nothing but a massive storehouse of ones and zeros. The tension or balance between civil liberties and national security is a debate as old as this country. But they're not mutually exclusive. They are hard, they're darn hard, but they're not mutually exclusive and they're not impossible. I know well how many threats we face around the world, and I don't take them lightly. The fact that we have not faced another major terrorist attack since 9/11 is a testament to the skill and the hard work of the intelligence community, and I tip my hat to them. I am absolutely committed to giving them the tools they need to keep us safe, consistent with their constitutional rights. But we live in an era of the most powerful spying tools the world has ever known. 25 years ago, conversations were ephemeral. They were conducted in person or over the phone, but now they occur over email or chat, and they're archived forever. Our medical, financial, and legal records are all online. So are our photos. Our cell phones track us everywhere we go. The data available on us is unprecedented, and the fundamental principle of the Bill of Rights is that we have the right to keep our data private. We need new safeguards to ensure that. So by rejecting this rule, we have a chance to do it better, and in so doing, both keep us safe and protect our constitutional rights. For these reasons, Mr. Speaker, I urge my colleagues to reject the rule, and I yield back.
Gentleman yields back.